Senate will please come to order. Move a devotional this morning. We will begin with a moment of silence. Thank you. Last senators to kindly stand for the pledge. I pledge
allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Are there any announcements as we begin this morning? The senator from Chittenden is recognized.
Thank you, Madam President. I would move that the rules be suspended for the purposes of taking pending entry on the notice calendar H730 liquor bill for the purposes of sending it to the Finance Committee pursuant to rule.
The senator from Chittenden has moved that the rules be suspended and H730 pursuant to Rule 31 be moved to the Committee on Finance. Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've suspended the rules and moved H730 to the Committee on Finance. We have one gubernatorial appointment this morning. The governor has appointed Amy Richardson of Woodstock as a member of Vermont Housing and Conservation Board. This appointment is referred to the Committee on Economic Development, Housing, and General Affairs. This does now bring us to the orders of the day. There's been a request to begin today with our third readings. We'll move ahead to those at this time. Beginning with H456. We have on the calendar for third reading H456, an act relating to establishing strategic goals and reporting requirements of the Vermont State Colleges. Third reading was ordered on April 29th. Are there any amendments before third reading? Please listen to the third reading of H456.
H456, an act relating to establishing strategic goals and reporting requirements for the Vermont State Colleges.
The question is, shall the bill pass in concurrence? Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay. The ayes appear to have it. The ayes do have it, and you've passed H456 in concurrence. We now have on the calendar for third reading H482, an act relating to miscellaneous changes to the Reach Up program. Third reading was ordered on April 29th. Are there any amendments before the senator from Windham is recognized?
Thank you, Madam President. I believe you said 482.
Excuse me, 464, thank you. We have on the calendar for third reading H464, an act relating to miscellaneous changes to the Reach Up program. Third reading was ordered on April 29th. Are there any amendments before third reading? Please listen to the third reading of H464.
H464, an act relating to miscellaneous changes to the Reach Up program.
You heard the third reading. The question is, shall the bill pass in concurrence? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've passed H 464 in concurrence. We have on the calendar now for third reading H 482, an act relating to the Petroleum Cleanup Fund. Third reading was ordered on April 29th. Are there any amendments before third reading of H 482?
H 482, an act relating to the Petroleum Cleanup Fund.
For the third reading, the question is, shall the bill pass in concurrence? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. Ayes have it, and you've passed H 482 in concurrence. We have on the calendar for third reading H 523, an act relating to reducing hydrofluorocarbon emissions. Third reading was ordered on April 29th. Are there any amendments coming before third reading? The third reading of H 523.
H 523, an act relating to reducing hydrofluorocarbon emissions.
You've heard the third reading. The question now is, shall the bill pass in concurrence? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. Ayes have it, and you've passed H 523 in concurrence. There's been a request to pass over H 606. We will move along to H 729, an act relating to miscellaneous fishery procedures, which is on the calendar for third reading. Third reading was ordered on April 29th. And I believe the senator from Wyndham White is recognized for a proposal of amendment that is found on pages 4187 to 4188 calendar. The senator from Wyndham is recognized.
Thank you, Madam President. If you remember, we passed some time ago S 155, which was creating the Agency of Public Safety from the Department of Public Safety. It was merely a reorganizational thing. Part of that was a study to be conducted by the Department of Public Safety in conjunction with Ag and other divisions and agencies in the state to look at a plan to unify domestic animal welfare and related public safety functions across state government. Currently, they exist in many different places, and a group of people who represent humane societies and other people are interested in looking at where it might be consolidated. And so we passed that in S155, and this is simply taking that study and putting it in the miscellaneous judiciary procedures bill. So we hope that you will support this amendment. Thank you.
The question is, shall the Senate propose to the House to amend the bill as moved by the senator from Wyndham and others? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. Ayes have it, and you propose to the House to amend the bill as proposed by the senator from Wyndham and others. I believe there's another proposal of amendment today offered by the senator from Bennington, Senator Sears, and the amendment is a calendar amendment and can be found on page 4188 of today's calendar. The senator from Bennington is recognized.
Thank you, Madam President. This amendment would allow the sealing of convictions for careless and negligent driving when no serious death or no serious bodily injury occurred. What happens generally, and I'll give you an example of a young person from Bennington, on his 21st birthday, he went out partying with some of his friends. And he was driving back to Bennington from New York and stopped the car and got out of the car, and the police stopped to check on the car, and he blew a .08, which is just at the legal limit. So the state's attorney, looking at the case, this is 19 years ago, said, we'll drop this to careless and negligent, which they frequently do on DUI cases. The going to turn 40, and he can't get this record sealed. But if he had been not pled down for DUI, he could get it sealed. So it's kind of an incongruity in our law that the lesser charge is not sealable, but the original charge of DUI is sealed. So this amendment would simply allow that record to be sealed. It has to go through all the processes of the state's attorney agreeing, the judge agreeing, and so forth. So it's not automatic. But I feel, and I think the majority of your Judiciary Committee feels strongly, that this is kind of an oversight and should have been taken care of years ago. With that, hopefully this would take care of that problem. Thank you, Madam President.
Question is, shall the Senate propose to the House to further amend the bill as moved by the senator from Bennington? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it. And you further propose to the House to amend the bill as proposed by the senator from Bennington. I believe there's one additional amendment today offered by the senator from Chittenden, Senator Rom Hinsdale, that can be found on the calendar on page 4189. The senator from Chittenden is recognized.
Thank you, Madam President. If you look at the language on page 4189, you'll see that it exactly mirrors the language that was proposed for the relief from abuse order section. And when I looked at the language in the relief from abuse order section, as someone who did those orders for many years, day in and day out, I was very grateful to the committee to see that they had created the opportunity for people to get that kind of order that largely serves people who are facing intimate violence, that they had created an opportunity for that person to get relief, temporary relief, without having to go to the courthouse. This language would now exist in parallel in a much lesser known section of law that supports elders who are experiencing exploitation. It is called a relief from exploitation order. And for many older Vermonters, there's not as much congruency to be able to access a relief from abuse order. This can be financial exploitation. It can be threats specifically based on household presence or financial burdens, et cetera. And in fact, the first time I helped someone get an order like this, they were an older gentleman who had AIDS, and he had a roommate that would get mad and wouldn't pay rent and would throw things at this older gentleman. And this particular man said, I'm worried that if my blood gets places, it's going to harm someone else. And I'd like to get this order so that I can have this person leave my house. That's a really high burden for a relief from abuse order. It's a much easier path to access a relief from exploitation order for an elder person. And so this language simply mirrors what's available in the relief from abuse order. I hope this gives folks a little bit of information about a much lesser known area of relief for people so that we can keep these provisions consistent between the two, because our elders deserve the same access to safety. And this provision in many ways will likely serve many older Vermonters who would otherwise have a hard time getting down to the courthouse to this kind of order. Thank you, Madam President.
The question is, shall the Senate propose the House to further amend the bill as moved by the senator from Chittenden? The senator from Bennington is recognized.
Madam President, the Judiciary Committee did not have time to take testimony on this particular amendment. However, through the good work of our legislative counsel, Eric Fitzpatrick, we sent out a memo to the Judiciary, the state's attorneys, the Defender General, as well as the Center for Crime Victim Services and the Vermont Network Against Domestic Violence and Sexual Assault. All except the state's attorneys have responded, and all of the responses were supportive of the senator's amendment. And so while the Senate Judiciary Committee has not taken a position, I particularly am supportive, and I hope the Senate will concur.
question is, shall the Senate propose to the House to further amend the bill as moved by the senator from Chittenden? Are you ready for the question? All those in favor, please say aye. Those opposed, nay. Ayes have it. And you further propose to the House to amend the bill as recommended by the senator from Chittenden. Are there any additional amendments before the third reading? Please listen to the third reading bill.
729, an act relating to miscellaneous judiciary procedures.
The question is, shall the bill pass in concurrence with proposals of amendment? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. Ayes have it, and you pass the bill in concurrence with proposals of amendment. We will now move back to the top of the calendar for today, beginning with JRH 18, a joint resolution relating to the Russian invasion of Ukraine. It was read for the first time on March 11th. It was referred to the Committee on Government Operations, which reports it has considered the resolution and recommends the resolution ought to pass. Please listen to the second reading of JRH 18.
JRH 18, joint resolution relating to the Russian invasion of Ukraine.
The senator from Windham, the chair of the Committee on Government Operations, is recognized for the report.
Thank you, Madam President. Earlier in the year, we appropriated $1 for each Vermonter for the sale of Russian alcoholic products to assist Ukraine. At the time, we expressed our anger and dismay at President Putin for the unwarranted invasion of Ukraine. Today, we have before us a resolution initiated in the other chamber that in more specific terms expresses that same anger and relates events as they were when this resolution was written. I'm not going to read it, but will just quote one of the whereases and make a few comments. Whereas deep national pride and a fierce anger at President Putin's vicious attack upon the Ukraine's sovereignty has united Ukrainians, and many Ukrainians have volunteered to defend their country. Vermont has strong ties to Ukraine, and many of our residents have families there, including members of the General Assembly who live every day with this nightmare. Perhaps a little known tie is the granite monument to honor captive nations that was carved in Barrie by our own Vince Aluzzi's father. It stands beside Taras Shevchenko's memorial in the National Mall. He was known for and imprisoned for pro-Ukrainian independence in Tsarist Russia. A different time now, but his words remain true today. Our soul shall never perish. Freedom knows no dying, and the greedy cannot harvest fields where seas are lying. Cannot bind the living spirit, nor the living word, cannot smirch the sacred glory of the Almighty Lord. It is hard to put into words the fierce pride and dedication of their country of the Ukrainian people. To share this, I would like to just share a personal experience of this pride. In 1972, I was a graduate student in Southern Illinois. A dear friend and fellow student who now lives in Vermont grew up in a large Ukrainian community in Cleveland. He taught me much, but primarily that the Ukrainian people are strong, proud, and determined. The experience I'm about to share demonstrates that truth. His father visited us from Cleveland. The visit included a performance in East St. Louis by the Ukrainian Ballet. The performance was held in a football stadium, and since East St. Louis also had a large Ukrainian community, it was filled. Remember, this was 1972, before the breakup of the Soviet Union, and Ukraine was referred to as the Ukraine. To make it clear, it was not its own country, but merely a section of the USSR. Loyalty to the Soviet Union was expected, and loyalty to one's country was judged harshly. Performance was spectacular. Beautiful dances, mostly in black and red outfits. The performance was over. People were grateful, but what happened next was truly awe-inspiring. The dancers came back on stage in the blue and yellow colors of Ukraine. They launched into a traditional Ukrainian dance. Sorry. It was very emotional. People jumped up, stood on the bleachers, stomped their feet. They were clapping and crying. It made hearts swell and brought tears seeing the fierce pride of the audience and the sheer bravery and determination of the dancers. That same pride, bravery, and determination is what we see today. Our committee vote was 5-0-0, and we hope you will pass this resolution to condemn President Putin and honor the people of Ukraine. Thank you.
The question now is, shall the resolution be read for the third time? Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay. The ayes have it, and you've ordered third reading of JRH 18. We have on the calendar for action H 279, an act relating to miscellaneous changes affecting the duties of Vermont Health Access. It was read for the first time on March 18th. It was referred to the Committee on Health and Welfare, which reported the bill be amended as set forth on page 5139 of today's calendar. And so amended, the bill ought to pass. The bill was then referred the Committee on Appropriations that reports that when so amended by the Committee on Health and Welfare, the bill ought to pass. Please listen to the second reading of H 279.
H 279, an act relating to miscellaneous changes affecting the duties of the Department of Vermont Health Access.
The senator from Addison, Senator Hardy, is recognized for the report of the Committee on Health and Welfare.
Thank you, Madam President. H 279 is the miscellaneous changes to the Department of Vermont Health Access bill. It is a pretty easy bill. There are 4 sections in the original bill, and one of those sections is actually deleted by an amendment from your Health and Welfare Committee. So if I may, Madam President, I will speak to both the underlying bill and the amendment.
You may.
Thank you. The first section of the bill relates to a small change in the Medicaid coverage for adult dental services. This one is special to me because this is my very first bill in the Senate 4 years ago. And it just makes a small change. In current law, there are up to 2 visits per calendar year for preventive dental services allowed under the Medicaid program. This changes it just to say prevented services and does not specifically call out 2 visits. And the reason this is because the Medicaid program has a difficult time counting the number of visits each individual person has, and so it became administratively burdensome. And sometimes there need to be follow-up visits for small procedures. So they requested that we just delete that so that there's not the administrative burden. The next 2 sections are just deleting language that was related to rulemaking and legislative oversight for new programs. These rules were made many years ago, and the language related to rulemaking is no longer necessary. The fourth section, which your Senate Health and Welfare amendment removes from the bill, is related to merging the small group and individual health insurance markets. And fortunately or unfortunately, depending on how you vote on it, this is handled in another bill. So we deleted it in the Health and Welfare Committee so that the Finance Committee could take that provision out in their own discussions. We heard from the officials at the Department of Vermont Health Access, our legislative counsel, and the reporter of the bill in the House. The committee vote was 5-0-0, and we hope that you'll concur. Thank you, Madam President.
Senator from Caledonia, Senator Kitchell, is recognized for the report of the Committee on Appropriations.
Thank you, Madam President. The Appropriations Committee reviewed this bill, and particularly Section 1, which has to do with Medicaid coverage. our determination was that the physical impact was negligible. What it really does is replace the 2-visit year with procedure codes of covered services, which would be the preventive services. And we recognize the administrative complexity of tracking up 2 visits. And so we, after reviewing that and recognizing that the section that is being deleted was also being addressed in a finance committee, the vote on H279 by appropriations was 601.
Question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Health and Welfare? Are you ready for the question? All those in favor, please say aye. Those opposed, nay. The ayes have it, and you propose to the House to amend the bill as recommended by the Committee on Health and Welfare. The question now is, shall the bill be read for the 3rd time? Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay. The ayes have it, and you've ordered 3rd reading of H279. We now have on the calendar for action H410, an act relating to the use and oversight of artificial intelligence in state government. It was read for the first time on March 18th. It was referred to the Committee on Government Operations, which reports that the bill be amended as set forth on pages 4140 to 4149 of today's calendar, and that when so amended, the bill ought to pass. The bill was then referred to the Committee on Appropriations, which reports it has considered the bill and recommends that when so amended as recommended by the Committee on Government Operations, the bill ought to pass. Reading of H410.
Page 410, an act relating to the use and oversight of artificial intelligence in state government.
The senator from Windham, Senator White, is recognized for the report of the Committee on Government Operations.
Thank you, Madam President, and hopefully you'll indulge me a little bit here. My glasses are steaming up because of my mask, so I'll do my best. May I report on the underlying bill as well as our amendments?
You may.
Thank you. The world of technology is changing faster than many of us can keep up with. Some of us actually feel left in the dust with these speedy changes. In 2018, Senate Government Operations was asked to establish the Vermont Artificial Intelligence Task Force. I just scratched my head and agreed with those who were smarter than I. In 2019, they asked for an extension, and we agreed because we didn't really know any better. As it turns out, those who made the request and became members of the task force were right and way ahead of me and some of others, and have now come to us with recommendations. Artificial intelligence, or AI, and I'll do my best, exists in and affects our lives in many ways that we don't even know about. We as a state need to know how it is used and how it should be used in state government. H410 is the result of the work of the task force. Section 1 is findings. Section 2 adds a requirement to the ADS's, Agency of Digital Services, annual report and budget. The requirement that they do an inventory of all AI that exists in the state, as defined in Section 3. Section 3 is the definitions. Here is where we depend on those smarter than I am. An algorithm means a computerized procedure. It comes consisting of a set of steps and to accomplish a certain task. Automated decision system means any algorithm, including one incorporating machine learning or other artificial intelligence techniques that uses data-based analytics to make or support government. Here's an example. And this example came both from my housemate and from the other body, the task force itself. We feed in information on 2,000 homeless individuals with different economic, health, and social needs. We also have data on housing types across the state. This can help guide where might be the best placements for specific individuals. Now we have an automated support decision system. Means an automated decision system that provides information to inform the decision, judgment, or conclusion of a human decision maker. For example, as given, was the option for suggested placements of the individuals, but humans make the final decision. Now we have an automated final decision system, makes an automated decision system that makes a final decisions, judgments, or conclusions without human intervention. In the example, this system would make placement decisions, period, no human involvement. And B defines the inventory to be conducted by ADS. I am not going to read all the things that are to be in the inventory. I'll leave that to you. Each year, the ADS needs to report on their findings. Let's see. Sorry. An advisory council for the division. I seem to have missed a section here. Section 4 requires a report of the inventory with recommended changes and maintenance and any recommended measures needed to address systems that are problematic. Section 5 creates the Division of Artificial Intelligence within ADS to review all aspects of AI systems developed, employed, or procured in state government. An advisory council for the division is created in 5013. There are 10 members who can meet not more than 12 times a year. This may sound excessive to meet every month, but this field is rapidly changing, and up to now we have not carefully looked at the use of AI in the state as it affects the lives of Vermonters. I will say that until I heard from the task force members, I, for one, did not appreciate the importance of understanding how this technology could impact our lives. The Advisory Council will cease in 2027, and recommendations for moving forward will be reviewed. Section 7 requires the council to submit reports, one in January 24 and one in January 25. Section 8 creates the position of director within the division, and Section 9 is the effective date. We heard from Robbie Adler, Chief Strategy Officer for Faraday, Mark Coombs, Chief Technology Officer, ADS, Justice Dooley, Artificial Intelligence Task Force, Mark Hughes, Executive Director of Vermont Justice for All, Kristen McClure, Chief Data Officer, ADS, John Quinn, Secretary of ADS, Stephanie Seguino, Professor, Department of Economics, University of Vermont, and Representative Brian Chena, the sponsor. It is hard to emphasize how important this topic is. Only after hearing from those involved with AI did I come to appreciate the importance. It can lead to cost savings and increased efficiency in state government. But certain forms of AI also carry a risk of privacy invasions, discrimination, and other impacts to civil liberties, particularly if not subject to proper oversight. Our committee vote was 5-0-0, and we ask for your support. Thank you.
The senator from Chittenden, Senator Baruth, is recognized for the report of the Committee on Appropriations.
Thank you, Madam President. Can you hear me all right?
We can.
The Committee on Appropriations did take up this bill. We looked primarily at two facets of it. One was the creation of the advisory council. And so we had the usual discussion of premiums for those individuals not covered by the salaries. And then Section 8, which authorizes the creation of a position, but it's a position to be transferred and converted from existing basic positions and funded from existing resources. So we felt that this was very much in line with the good work that this division will do. and our vote was 6-0-1 in favor. Thank you.
Thank you. The question is, shall the Senate propose to the House to amend the bills recommended by the Committee on Government Operations? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. Ayes have it, and you propose to the House to amend the bill as recommended by the Committee on Government Operations. The question now is, shall the bill be read for the third time? The senator from Addison is recognized.
Madam President, may I inquire of the recorder, please?
You may.
The question I have is about protection. So I'm delighted that the committee is moving this forward. In section 5012, where the Division of Artificial Intelligence is set up, there's a report that refers to policies. I guess these would be future policies designed to protect privacy and things like that. And I just wondered if you could speak a little bit more. When we talk about artificial intelligence, it sounds cool, calm, collected, rational, but it also has the ability to embody prejudices. Like redlining in housing is really an algorithm. It wasn't necessarily carried out by a computer. So can you talk a little bit about what you've learned so far and about how we're going to avoid building prejudice into these computer systems and be able to see that, detect that, and protect against it?
Thank you, Madam President. I am looking, if we look on page 4142, number 4, in the inventory that's being conducted by ADS, one of the things they need to address is whether the automated decision system has been tested for bias by an independent third party, has a known bias, or is untested for bias. So that will be part of the inventory. Then if we move to page 4144, and I am looking at trying to find where we put this in. Well, one is B, to any policies that might be necessary to ensure that, thank you, Vermonters are free from unfair discrimination caused or compounded by the employment of artificial intelligence in state government, and address the use or prohibition of systems that have not been tested for bias or have been shown to contain bias. So the first step is to do an inventory and figure out whether we do have systems that either contain bias or have not been tested for bias. And then the recommendation will come back of how to deal with those. Do we want to prohibit their use if they haven't been tested, or if they show that there is a bias, and what will be the policy around that? I hope that answers the question, Madam President.
Thank you, Senator. Thank you, Madam President.
The question is, shall the bill be read for the third time? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've ordered third reading of H 410. There's been a request to now take up H 782, 728. I'm finding more and more out about myself every day here. H 728. An act relating to opioid overdose response services, read for the first time on March 30th. It was referred to the Committee on Health and Welfare, which reports that the bill be amended as set forth on pages 4157, 4163 of today's calendar, and that when so amended, the bill ought to pass. The bill was then referred to the Committee on Appropriations, which reports it has considered the bill and recommends that when so amended, as recommended by the Committee on Health and Welfare, the bill ought to pass. Please listen to the second reading of H 728.
H 728, an act relating to opioid overdose response services.
Senator from Addison, Senator Hardy, is recognized for the report of the Committee on Health and Welfare.
Thank you, Madam President. As everyone in the chamber is well aware, we are in the midst of an enormous public health crisis in Vermont related to opioid use and opioid deaths. Preliminary 2021 opioid-related accidental and undetermined fatal overdose data, increase in opioid-related fatal overdoses. At this time, the data shows approximately a 33% increase from 158 deaths in 2020 to 210 deaths in 2021. At the time, we were having a crisis, another public health crisis with the COVID pandemic. We are having a simultaneous public health crisis with the opioid death crisis in our state. So H728 is a bill that is intended to, at least in part, help to address this crisis. As the president said, it is brought to you on page 157. When the bill came over to us from the House, this bill included a number of appropriations for various harm reduction and drug use prevention programs throughout the state. However, many of those programs, between the House's work on the bill and our work on the bill, now have federal funding. So what you'll see as sort of a theme throughout my report, that we, instead of providing appropriations for specific programs, asked the Department of Health to report back to us on the use of the federal funds that they now have for these uses, and let us know how they were using the federal funds. But in the first section of the bill, this is a strike all bill that you can find on page 4157. The first section of the bill actually changes the definition of the term drug paraphernalia and includes what it does not include in that definition. Does not include needles, syringes, and the added or other harm reduction supplies distributed or possessed as part of an organized community-based needle exchange program. So if those things are from a needle exchange program, they are not considered drug paraphernalia for the purposes of criminal prosecution. The second paragraph is a change that changes who can run a needle exchange program. Under current law, those must be operated by an AIDS service organization, a substance abuse treatment provider, or a licensed healthcare provider or facility. This is struck in this bill to allow more organizations to provide needle exchange programs. There was testimony that said that these programs this language is too restricted. There are other programs that have the capacity to do needle exchanges, and so this would open it up to the possibility of other organizations creating needle exchange programs. They still would have to be consistent with the provisions of current law and under the direction and oversight of the Department of Health, but it just allows other organizations to run that. And then section 2, of course, requires a report on needle exchange programs guidelines due back to the legislature in 2023. The next section is about prior authorization of Medicaid-assisted treatment, or MAT as it's known. This section 3 provides that coverage to Medicaid beneficiaries for medically necessary Medicaid-assisted treatment for opioid use disorder, when prescribed by a healthcare professional practicing within the scope of the profession's license and participating in the Medicaid program, does not require that should be covered by Medicaid, and that Medicaid shall cover at least one medication in each therapeutic class for methadone, buprenorphine, and naloxone as listed in the Medicaid's preferential direct drug list. So this is expanding the use of MAT and coverage by the Medicaid program. Then there's, of course, a report for that as well about Medicaid-assisted treatment and prior authorizations. And this report would come back to the legislative committees in December of 2022 and submit its finding related to prior authorizations, Medicaid-assisted treatment, to the Drug Utilization Review Board and the Clinical Utilization Review Board for their review. And there are a number of provisions that are required in that report. And then on the bottom, in section 7, there's another report about prior authorizations. And this one does come back to the legislature about prior authorizations for MAT in the Medicaid program. And then in section 8, we create yet another working group on overdose prevention sites, which are also known as safe reduction sites. When this came to the Senate from the other body, this working group was in this report. Members of your Senate Health and Welfare, namely me, wanted to make sure that this working group was a little bit more proactive. There have been a number of working groups and studies throughout the past number of years about the efficacy of safe injection sites or safe or overdose prevention sites. Most of the research has overwhelmingly shown that these sites are effective and that they can be run safely. There are some barriers related to federal law and law enforcement oversight that need to be worked out first. So what we did was sort of beef up the language related to the overdose prevention site working group and asked them to provide a report to us back in January of 2023. The other body had this in December of 2023, so we moved it up and we asked for an actionable plan for the design, facility, fit up, implementation, and one or more overdose prevention sites in Vermont. And there's an amendment that you'll see later that actually asks them to provide us with that plan and a budget proposal for that plan next legislative session. So hopefully this will lead to some more work in that area. The next several sections of the bill are, as I said before, areas that have now been provided with federal funding. And so we just asked for the reports on that use of the federal funding for mobile medication assisted treatment, so mobile MAT programs, substance use support for justice involved Vermonters, and overdose emergency response support. As I said, each of these has some federal funding, so we're just asking for reports back next session to the committees of jurisdiction, and these can be oral reports, just wanting to make sure that we're staying on top of what's happening, particularly with the most recent influx of the settlement funds that the chair of the committee reported on earlier in a different bill. The committee vote was 4-1-0, and we heard from a number of witnesses, including people from the Department of Health and the Department of Health Access, from several local drug use prevention programs here in Montpelier and also Burlington and other parts of the state. Of course, from our Joint Fiscal Office, Legislative Council, and 2 reporters from the other body. And as I said, Madam President, the vote was 4-1-0, and the committee asks for your support. Thank you.
The senator from Lamoille, Senator Westman, is recognized for the report of the Committee on Appropriations.
Madam President, the Appropriations Committee took a look at it, but as we heard from the reporter, the bill was a strike all that came over from the House. The underlying bill that came from the House had appropriations. In the Senate version that came from Health and Welfare, there were no appropriations in the bill. The Appropriations Committee approved the bill 6-1.
The senator from Addison, Senator Hardy, is further recognized for a recommendation of amendment, which I believe is found on page 4163 of today's calendar. Senator from Addison is recognized.
Thank you, Madam President. So as I mentioned in my report, this amendment just beefs up the information that we are asking for from the overdose prevention site working group, to ask them to provide us with the plan that we asked them for. We had asked them for the plan, but then we failed to ask them to give us the plan. So this amendment just asks them to give us that plan when they report back their findings and recommendations. And then the second instance of amendment is one that came out of the discussion with the Appropriations Committee, and it inserts language in Section 9 related to the Mobile Medication Assisted Treatment Program, and asks that part of their respective presentation be the designated agencies in the department shall describe the geographic inequities in the provision of methadone services and provide proposals for addressing geographic inequities. There's a concern, like there is with many health and welfare type programs, that there are areas of the state that are unserved, and we're wanting to make sure that these mobile MAT treatment programs serve all areas of the state and are there for people who need them in their communities. So those are the two amendments. Thank you, Madam President.
The question is, shall the report of the Committee on Health and Welfare be amended as moved by the Senator from Addison and others? The Senator from Essex Orleans is recognized.
Madam President, could I interrogate the presenter of the amendment, please?
You may.
I'm curious as far as if the committee took any time to discuss when in Section 1A1, when a needle would be or a spent needle or if that would be considered drug paraphernalia at that time. If it was discovered in a children's park or on the roadside or at any time of that, is that drug paraphernalia at that time, or is it just not a drug paraphernalia ever?
If it is distributed by an official organization, the community-based needle exchange program, it would not be considered drug paraphernalia if it's possessed by an individual who's using it. If it's spent and thrown on the ground, then that would be basically medical waste. So that if it's not attached to a person, if it's just on the ground, Madam President, then I would assume that would be considered trash. I'm not sure if I understand the question. If it's not on a person.
If it wasn't distributed towards from one of these sites and it was just bought off the street or bought anywhere else, is that same needle, is that when it's cast along the roadside, is that, Madam President, is that drug paraphernalia, or is it just a difference if it's distributed by this framework? I'm curious about when a needle that's been used to inject harmful drugs into your body, if it's ever going to be considered drug paraphernalia.
Oh, I understand, Madam President. Yes, if it is distributed by one of these organizations for a safe needle exchange program, that it would not be considered drug paraphernalia. But if it is just exchanged on the street through other means, then it would be considered drug paraphernalia. It has to be officially from one of these recognized programs to be exempted from drug paraphernalia.
And Madam President, would we know where, if it was where it originated from? Would we know? Would it be marked in a certain way that we could determine whether it was drug paraphernalia or not? If law enforcement was trying to do their job, would they be able to tell where this needle came from that was filled with heroin, fentanyl, or anything like that? Would we know whether it was legally drug paraphernalia or not at any time?
I'm not sure if these organizations have some type of marker or identification on the needles and other harm reduction materials that they provide. I can certainly find that out by third reading.
Thank you, Madam President.
The question is, shall the report of the Committee on Health and Welfare be amended as moved by the Senator from Addison and others? Question. The Senator from Chittenden is recognized, and we'll move to the Senator from Bennington.
Thank you, Madam President. As the Senate knows, I have elementary school children, and I'm constantly counseling patients. I suppose I should listen to my own message. I was pleased to sign on to a bill when I first arrived in the Senate, sponsored by the Senator from Essex Orleans, John Rogers, to permit safe injection sites. That was 6 years ago. At the time, the feds quickly reacted to us and other states that were looking at cities around the country and made it clear that they were not permitted. Since then, however, the federal government has softened its stance on safe and supervised injection sites. And in fact, there are several running around the country with very clear outcomes. Positive outcomes, lives being saved. And here we're being asked to support a study. How many more Vermonters will die while we continue to study whether or not this proven response to an opioid overdose crisis is suitable for Vermont? It's very frustrating. I'm running out of patience. No others, including the reporter, feel the same. So I don't, I'm not sure what to suggest. I'm not about to offer an amendment to say we should do this, to greenlight it. But I do think it's important to recognize that it is high time we adopt this straightforward harm reduction strategy. And I suppose I understand my third graders' lack of patience when we have to look at families and simply say we're studying the response. And I would just note, somebody pointed out, I forget where I read it, we have supervised consumption sites of all kinds. They're called bars. More people die from alcohol than just about any other substance. But you can walk into any town in this state and order a drink and have a professional licensed by the state administer that drug to you, Madam President. So this is not some foreign concept, not actually worthy of a study, it's worthy of executing. And it's unfortunate that we're going to ask Vermonters to wait another year.
The senator from Bennington is recognized.
Madam President, on a different note, I wanted to thank Senator from Madison and the Health and Welfare Committee for the amendment looking at the geographic disparities. Few people probably are aware that Bennington County, one of our larger counties in the state, has no methadone access available to its residents. They either have to go to Rutland if they can get in, Rattleboro if they can get in, or North Adams, Mass if they can get in. As a matter of fact, Madam President, we had to get special permission for parolees to be able to go out of state to get methadone treatment that they were able to get inside some of our facilities. So, Madam President, I think it's very important to begin to look at the geographic disparities regarding treatment for opioid abuse. Thank you.
Question is, shall the report of the Committee on Health and Welfare be amended as moved by the senator from Addison and others? The senator from Addison is recognized.
Thank you, Madam President. I just wanted to thank the senator from Chittenden for his remarks. I couldn't agree more. And also to let you all know that we did hear in testimony in the Health and Welfare Committee that there is potentially a federal announcement in the works for later this month. We heard the date of maybe May 15th. That may make the path for a safe injection site easier from a federal perspective. So we are hoping that that does happen and that this report might actually lead to some action this time around. But I share the frustration and patience. I hope that we'll move this forward so we can hit the ground running as soon as that hurdle is cleared. Thank you, Madam President.
Are you ready for the question? And the question is, shall the report of the Committee on Health and Welfare be amended as moved by the senator from Addison and others? All those in favor, please say aye.
Aye.
Those opposed, nay.
No.
The ayes appear to have it. The ayes do have it, and you've amended the proposal of amendment as proposed by the Committee on Health and Welfare. The question now is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Health and Welfare as amended? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay.
No.
Ayes appear to have it. The ayes do have it, and you've proposed to the House to amend the bill as recommended by the Committee on Health and Welfare as amended. The question now is, shall the bill be read for the third time? Are you ready for the question? All those in favor? The senator from Rutland has requested a roll call vote. Are you ready for the question? Again, the question is, shall the bill be read for the third time? The secretary is kindly asked to call the roll.
Senator Ballant.
Yes.
Senator Baruch.
Yes.
Senator Benning.
No.
Senator Bray.
Yes.
Senator Brock.
No.
Senator Campion.
Yes.
Senator Chittenden.
Yes.
Senator Clarkson.
Yes.
Senator Collmore.
No.
Senator Cummings.
Yes.
Senator Hardy.
Yes.
Senator Hooker.
Yes.
Senator Ingalls.
No.
Senator Kitchell. Senator Lyons.
Yes.
Senator McDonald.
Yes.
Senator Mazza.
Yes.
Senator McCormack.
Yes.
Senator Nitka.
Yes.
Senator Parent.
No.
Senator Pearson.
Yes.
Senator Perschlick.
Yes.
Senator Polina.
Yes.
Senator Ron Hinsdale.
Yes.
Senator Sears.
Yes.
Senator Sorotkin.
Yes.
Senator Starr.
Yes.
Senator Terenzini.
No.
Senator Westman.
No.
Senator White.
Yes.
Senator Kitchell.
Please listen to the results of your vote. The yeas 22, the nays 7, and you've ordered third reading of H 728. There's been a request to move back to H 546, an act relating to racial justice statistics. It was read for the first time on March 24th. It was referred to the Committee on Judiciary, which reports the bill be amended as set forth on pages 4149 to 4146 of today's calendar, and that when so amended, the bill passed. The bill was then referred to the Committee on Appropriations, which reports it has considered the bill and recommends that when so amended as recommended by the Committee on Judiciary, the bill ought to pass. Please listen to the second reading of H 546.
H 546, an act relating to racial justice statistics.
The senator from Wyndham, Senator White, is recognized for the report of the Committee on Judiciary.
Thanks, Madam President. May I report both the underlying bill and our amendments?
You may.
Over the years, concern has grown over discrimination and racial disparities in our criminal justice system. The Judiciary Committee and Senate Government Operations have both heard reports from the Council of State Governments with recommendations to address this concern. A few years ago, we established the Racial Disparities in the Criminal and Juvenile Justice System Advisory Panel, a long title, but it's commonly known as RDAC. They have been working to come up with the best ways to collect these statistics. H 546 comes from their work. It creates a division of racial statistics within the Office of Racial Equity to collect and analyze data related to systems, systemic racial bias and disparities within the criminal and juvenile justice system. It has the following duties, and I'm going to, if you turn to page 4150, you can see what those duties are. I'm not going to read them. I did say that it will have the work with and have the assistance of defined state and local government agencies and departments to collect the data. It will collect and analyze the data, conduct justice information sharing gap analysis, maintain an inventory of justice technology assets and a data dictionary to identify elements and structure of databases and relationships, develop a justice technology strategic plan, develop interagency agreements and memorandum of understanding for data sharing, and report its data. There will be an annual report to Senate Judiciary, Senate Government Operations, and House Judiciary and Government Operations. Section 5013 requires the division to work with RDAP and the Racial Justice Statistics Advisory Council to establish the data to be collected. You'll find that the I haven't reported yet on the Racial Justice Statistics Advisory Council because it hasn't been created yet. It's going to be created a little further on in the bill. It defines that the data collected will be exempt from public records, but will give aggregate reports periodically. It will define which state and local agencies or departments possess the data and require them to comply with the requests for the data. And it will work with state archives to establish a management program for the information. The division will analyze the data and share it with the advisory council. It shall also establish a governance policy. While as noted above, the personal data is confidential, the division will maintain an accessible website to allow the public to understand the data collected. 5014 establishes the Racial Justice Statistics Advisory Council. It is made up of 7 members, 1 person with substantive expertise in community-based research on racial equity, appointed by the governor, and 6 members from impacted communities. The council will work with the director of the division to implement the objectives of this chapter. It will report monthly on findings and recommendations to RDAP and annually to the legislature. The council may meet monthly. Section 3 creates 3 new positions within the division, 1 full-time exempt division leader and 2 full-time exempt positions. All of them will be information technology data analysts. Section 4 appropriates $363,000 for the Office of Racial Equity, $3,316 for council per diems, and $520,000 to ADS to support the division. The bill was reviewed by both Senate Judiciary for the content and Senate Government Operations for the organizational structure. Both committees heard from Susanna Davis, Executive Director of Racial Equity, Eric Fitzpatrick, our Legislative Counsel, Jay Green, Racial Equity Policy and Research Analyst, Office of Racial Equity, Mark Hughes, Executive Director of Vermont Justice for All, Robin Joy, Director of Research Crime Research Group, Eitan Nasrin Longboat, Chair of the RDAP, Falco Schilling, the Executive Director of ACLU, and Rebecca Turner, Attorney for the Appellate Division of the Office of Defender General. There will be an amendment later on before 3rd reading because I think it was my fault that it didn't get up, and it relates to the enforcement and how the agencies and the local law enforcement agencies will be and the enforcement of their data collection, how it will be enforced. So that will be coming later on. The Senate Government Operations Committee supported the bill informally, and the vote in Judiciary was 5-0-0, and we ask for your support.
The senator from Chittenden, Senator Baruth, is recognized for the report of the Committee on Appropriations.
Thank you, Madam President. In some ways, the discussion the Appropriations Committee had on this bill mirrored the discussion we had on the Division of Artificial Intelligence. They were both involved with creating a division, creating an advisory council, and then the ensuing costs for those particular things. Obviously, this bill has a much more hefty price tag, but it is doing work that was envisioned originally when we created the Director of Racial Equity position. And I'm pleased personally to see this division situated now in the Office of Racial Equity. I think that makes great sense. And so the Appropriations Committee was operating on that long-standing assumption that we would at some point need to provide real hardcore expertise in data in order to accomplish the goals that we set out in other major legislation. And so we discussed the three positions, and we discussed the per diems for the members of the advisory council and funding for the agency services. And the committee was 601. Thank you, Madam President.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay. Ayes have it, and you propose to the House to amend the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read for the third time? Are you ready for the question? All those in favor, please say aye.
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 Those opposed, nay. The ayes have it, and you've ordered third reading of H 546. We now have on the calendar for action H 550, an act relating to prohibiting racially and religiously restrictive covenants in deeds. It was read for the first time on March 22nd. It was referred to the Committee on Judiciary, which reports has considered the bill and recommends that the bill be amended as set forth on pages 4156, 4157 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of H 551.
H 551, an act relating to prohibiting racially and religiously restrictive covenants in deeds.
The senator from Caledonia, Senator Benning, is recognized for the report of the Committee on Judiciary.
Thank you, Madam President. May I refer to the underlying bill as well as the...
You may.
Madam President, I thought I'd begin my report at the very beginning, specifically on that day when a boat from Europe, called the Mayflower, ended up docking Plymouth, Massachusetts. A group of folks carried a tradition onto the shore in which they literally decided to draw lines on property and place themselves on each one of those plots, then record that in a record book. As the European immigrant population began to work their way north, eventually to the area we now call Vermont, that tradition of having a deed to mark your property boundaries continued. And each time that property transferred hands, there was a document known as a deed, and it sometimes came with a covenant of some kind. It might have been restrictive, but those deeds collectively formed a chain of title. And it may be, in fact, some of the people in this room own property that have a chain of title that goes all the way back to prior to the date that Vermont actually became a state. Somewhere along the way, it was decided that the chain of titles were becoming so lengthy that the decision was made to go back 4 years to investigate your chain of title, and that would be enough. The problem is that virtually all of the titles that we hold to our property contain a provision that goes something like this. This deed references all prior deeds and restrictions You may refer to the prior chain to determine what they are. But in the event you have not gone beyond the 40-year time period in which you are searching your chain of title, you may not have any idea what's actually contained in your chain of title. This became problematic for a lawyer named Bill, who was from down country but decided he wanted to come to Vermont. Being the intelligent man that he was, he chose the most lovely part of Vermont, i.e. the Northeast Kingdom. And he purchased a piece of property on Caspian Lake in Greensboro. Bill would actually go on, after having conducted his 40-year title search, finding no problems, he would go on to be nominated for the United States Supreme Court. And you know him today as Justice William Rehnquist. When he was up for that election, he was, I guess you would say, targeted by opposition research. And it came to pass that in his chain of title predating the 40-year time period, there was a provision that effectively said no person of the Hebrew faith may own this property. That's called a restrictive covenant. This bill came to us from the other body with several sections in it. One established a state policy that any such restriction was null and void. Another was that in the future, no such restrictive covenants would be imposed. There was a third section that the other body tried to bring into the picture, which would enable an individual to create a subsequent link in the chain and have a statement effectively saying, we release this property from all prior restrictions. Your Judiciary Committee, Madam President, decided that that latter portion was a bit too far. It would put people into the position of having to literally research their chains of title if they wanted to be politically correct, if you will, and research 200 plus years worth of history to determine whether such a restriction exists on their property, and that it would add a link in the chain of title that really didn't make any sense if the state took a policy of saying we null and void all existing restrictive covenants and we prohibit their being enacted in the future. So, Madam President, your Judiciary Committee came up with the amendment that is found on page 4156 of today's calendar, and it basically does two things. First, it states the legislative intent, which is pretty clear, and it makes the historical notation that we are not historically perfect in how we formed this union, but we are constantly striving to become perfect. Section 2 talks about racially and religiously restrictive covenants and deeds, and they are now prohibited. Not only are they declared null and void if they exist, they are also prohibited in the future. Your committee, Madam President, heard from Terry Corsones, the Executive Director of the Vermont Bar Association, our Legislative Counsel, Eric Patrick, Reverend Mark Hughes, who's Executive Director of Justice for All, James Knapp, the co-chair of the Vermont Bar Association's Property Law Section, and Dan Richardson, currently the Burlington City Attorney, and interviewed today as his appointment to the Vermont Superior Court bench. Your committee vote was 5-0, and I will add a postscript to this report. About a year ago, I had a wonderful lunch with Executive Director Bohr Yang of the Human Rights Commission and Coach Christie, representative from the Hartford area. And the three of us were talking about various subjects, amongst which were these restrictive covenants. And after that lunch, Bohr Yang sent me a book called Color of Law. And if you really want to dive into this subject and learn how atrocious some of the things were in how people were literally kept out of certain areas, be it either religiously based restrictions or racially based restrictions, It really was an eye-opener to read that book. In short, Madam President, your committee vote being 5-0-0, we would ask for this body's support. Thank you, Mr. President.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? The senator from Washington is recognized.
Yes, thank you, Madam President. I want to thank your Committee on Judiciary for taking this issue up, taking this bill up from the House. There was a similar bill that I was a sponsor of, a Senate bill. So I was glad to see that the House passed this so this could be addressed. And I wondered if I could inquire of the presenter.
You may.
This came up because I had constituents right here in Montpelier that discovered one of these restrictive covenants on just the simple house that they owned here in town, and notified some neighbors, and others had found these on there. And they found these covenants, as you can imagine, to be abhorrent and really wanted to get them removed, even though they were in the distant chain, as was explained well by the presenter. My understanding is that this bill does not, as recommended here, would not remove the covenants from that chain, but just make it clear that they are non-enforceable. But my question is on the subsection A of section 2, where it says that, no deed recorded on or after July 1st, 2022 shall have these. Does that include the chain? Because what I heard from some lawyers when I was researching this issue is that you could kind of clean the title by resubmitting it without that on there. I didn't know if that was the intent of that subsection A, or the subsection A was just reiterating, which is already federal law, that you can't have any of these restrictive covenants.
First, Madam President, let me say that there is no way to quote unquote clean a chain of title. That would literally require someone with a pair of scissors going back into land records and excising offensive provisions. We had, coming over from the other body, an attempt to add a new link in the chain, if you would, that would effectively say, I hereby declare any such terrible language in my deed to be null and void. But that was redundant to what was actually intended in the first place, which is all of society simply declaring, we find these to be abhorrent. We say officially that they cannot be placed in any future deeds, and anything that may have existed prior to this particular date that's noted by the senator from Washington, they are officially declared null and void and unenforceable.
All right, thanks, Senator. Thank you, Madam President.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you propose to the House to amend the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read for the third time? The senator requesting a roll call, could you please request it again?
Not they froze. We got a problem.
We have a slight IT challenge, and you are quite frozen, so we will take a moment for the screen to resume unless the senator.
Just a point of order. I didn't hear a roll call. I just thought that maybe a delayed vote.
Okay.
We're going to have to go on a recess.
We're going to take a brief recess until the senators joining us remotely are able to rejoin. The senator. The Senate will please come to order. We're returning from a brief recess due to a technical difficulty. The question is, shall the bill be read for the third time? I thought I had heard a request for a roll call vote. That may have been an error, so I will give a moment to allow any senator who wishes to request a roll call vote to do so at this time. The senator from Caledonia is recognized.
I'll ask for a roll call.
The senator from Caledonia has requested a roll call. Are you ready for the question? And the question is, shall the bill be read for the third time? Secretary is kindly asked to call the roll.
Senator Ballant.
Yes.
Senator Baruch.
Yes.
Senator Benning.
Yes.
Senator Bragg. Senator Bragg.
Yes.
Senator Brock.
Yes.
Senator Campion.
Yes.
Senator Chittenden.
Yes.
Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Cummings.
Yes.
Senator Hardy.
Yes.
Senator Hooker.
Yes.
Senator Ingalls.
Yes.
Senator Kitchell. Senator Lyons.
Yes.
Senator McDonald.
Yes.
Senator Mazza.
Yes.
Senator McCormack.
Yes.
Senator Nitka.
Yes.
Senator Parent.
Yes.
Senator Pearson.
Yes.
Senator Perschlick.
Yes.
Senator Polina.
Yes.
Senator Ram Hinsdale.
Yes.
Senator Sears.
Yes.
Senator Sorotkin.
Yes.
Senator Starr.
Yes.
Senator Terenzini.
Yes.
Senator Westman.
Yes.
Senator White.
Yes.
Please listen to the results of your vote. The yeas 30, the nays 0, and you've ordered third reading of H 551. We have already completed H 728, and there's been a request to pass over S 210. We will move on to S 280, an act relating to miscellaneous changes to laws related to vehicles. The House has proposed to the Senate to amend the bill as set forth on pages 4177 to 4184 of today's calendar. The underlying question is, shall the Senate propose to the House? Actually, I believe we will start with a proposal of amendment as offered by the Senator.
The underlying question.
The underlying question is, shall the Senate concur with the House proposal of amendment? The senator from Washington is recognized.
Thank you, Madam President. Yes, the members of your Senate Transportation Committee have a further proposal of amendment that I've never presented before. So for me, the easiest way to present it is to go through what the House had proposed to amend that starts on 4177. We didn't add, our further proposal amendment doesn't add any language. We just took language away from what the House had proposed. So I'll just go through their proposals of amendment and tell you what we kept and what we took away. The first instance of amendment just clarifies the program on the total abstinence program. If you remember, one of the only thing of this bill when I presented it originally that was discussed. There's just further clarification, the definition of a regulated drug that would allow a prescribed drug to be used, but not used while driving. There's a second instance of amendment has several different parts that we kept some and took some out. The first section or part of this was section 10. It deals with transportation network companies. These are like Lyft and Uber there's a state regulation on this that preempts any municipality regulating these kind of companies. The city of Burlington has an exemption for that. That exemption expires in July of 22. We accepted their proposal to extend this to 2025, and it also includes a study, a work group to look into this issue and see if by 2025, should the municipality be allowed to continue not to be preempted by the state rules. And so they will come back before then to tell us if that preemption should hold or be changed at all. The House added several studies. We took the next three out: a report on increasing weights of trucks, a report on distracted driving, a report on idling. We took all those out. We didn't think they were needed. In section 15, the statement of policy, we kept parts where they just referred to the climate action plan. In the existing statement of policies for the Agency of Transportation, it often would say that the program work of the agency had to be in compliance with the comprehensive energy plan, but now we also have the climate action plan. So wherever it said comprehensive energy plan and they had added the climate action plan, we are agreeing with that. We took out any other language, any other extra superfluous language or requirements of the agency we did not agree with. But any small changes, like there was a reference to the Climate Change Oversight Committee, that doesn't exist anymore, but we have the Climate Council now. So changes we agreed with, and when they mentioned the Climate Action Plan, we agreed with, but when they added more work or more studies, we took that language out. For example, on page 4183, they had some pretty elaborate emission modeling that the Climate Action Council will be doing, but we didn't think that needed to be added as a burden to the agency. And then they made some changes to the effective dates that we also agreed with. And those constitute the further cases of amendment that the members of the Senate Judiciary Committee are recommending that this body agree with. Thank you, Madam President.
The question is, shall the Senate concur with the House proposal of amendment as amended with a further proposal of amendment as proposed by the Senator from Washington and others? Are you ready for the question? Senator from Windsor is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill?
May.
Thank you. Madam President, in section 12, it's a puzzlement to me why the state would not be wanting to actually look in depth at what is destroying our road services and bridges at an alarming rate, which are the ever increasing weight of trucks. It's a disconnect to me to be the stewards for the committee of the stewards of our roads and bridges to not wanting to actually study a significant percent of their impact. And so I'm just curious what the reasoning was behind taking away this study.
Thank you, Madam President. This study isn't about the damages that the large trucks do. This is a report on increasing them. So currently it's 99,000 pounds, or 107,000 pounds. This would increase it to 117,000 pounds. So we were concerned, like the concerns raised were concerns of ours, and this was specifically around logging trucks, and there was concern about the damage that these extra large or extra heavy trucks can do to local roads. The loggers can get permits. This was just going to lower or increase the level at which they need a special permit. We thought that the current procedures for requiring a permit when you go over the 107,000 pounds was warranted and didn't need further studies.
Thank you, Madam President. That's great to know. And had I read it in more depth, I needed to ask this question. I guess then my further question would be a study on a weight's impact on our roads and bridges that maybe would be a good thing to be having at this point, given your concern, as is my concern, that increased weights are having a detrimental effect on our roads and bridges.
Thank you, Madam President. It is something that your your Transportation Committee does discuss regularly. We are talking about how the interaction between the state limits and the towns, because this often is an issue on the smaller town roads and the gravel roads. So it's something that we're discussed. It's something that we hope to continue to discuss to find out, what the best path forward is.
Great, thank you. I applaud that work.
The question is, shall the Senate concur with the House proposal of amendment as amended with a further proposal of amendment as proposed by the Senator from Washington and others? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it. You concur with the House proposal of amendment as amended with a further proposal of amendment as proposed by the Senator from Washington and others. We have completed the third readings for today, so we are going to move forward to H500. We have on the calendar for action H500, an act relating to prohibiting the sale of mercury lamps in the state. It was read for the first time on March 18th. It was referred to the Committee on Natural Resources and Energy, which reports has considered the bill and recommends that the bill ought to pass. Please listen to the second reading of H500.
H500, an act relating to prohibiting the sale of mercury lamps in the state.
The Senator from Addison, Senator Bray, the Chair of the Committee on Natural Resources and Energy, is recognized for the report.
Thank you, Madam President. I hope folks can hear me in the last 3 minutes. It's audio for a few folks attending remotely as we're cutting in and out. So let me jump right in. H500, an act that specifically relates to the state of Vermont. Sometimes we think of a bill because there's a problem we're trying to address. Sometimes we think of a bill because there's an opportunity for us to seize. And in this case, this bill is both. The problem is mercury is well-known, environmental toxin, it's persistent, it bioaccumulates in the environment, and it poses a serious threat to humans, particularly young children, developing fetus, and in wildlife. So you need to make this up for jurisprudence, the amount of mercury in commerce, and then we are exposed to. And in this case, this bill proposes to do the same thing by eliminating 4-foot fluorescent tube lamps that currently have mercury in them. The positive side of this is that there is a safer, cleaner mercury-free replacement in the form of an LED tube lamp that plugs into the very same fixture. 93% of the cases, it's a simple replacement of the bulb. In some cases, lamps 7%, you may need an adjustment because the electronics of the base unit are not suitable. But the good news about that replacement is that these LEDs, everyone's familiar with them, they use half the electricity of the fluorescent, so they're 100% more efficient, and they also last 2 to 3 times longer. We've delayed doing something like this because in the past, the selection of LEDs, LED tube replacements, they were still in development, and they first find concerned they were too hard to come up. But now there are over 25,000 such varieties of commerce, and they're readily available. So the bill lays out, the findings talk about both the toxicity and the problem to public health and welfare. They also lay out the facts and figures for the fixtures themselves. In section 2, we provide a technical definition of precisely the 4-foot linear fluorescent lamp that we're talking about replacing. They come in all the traditional sizes. People may know them as 5s, 8s, 10s, 12s. And then section 3 is the Harley Building Limit Action. And that is collection plans beginning on January 1, 2024 of this sort may no longer be offered for sale in the state of Vermont. And there is, you'll notice for January 2024, we have roughly a year and a half lead into that transition, so that as with other transitions of materials like this, we provide for enough time for two things to happen. That one is that existing stocks can be sold out, and newer LED type bulbs can be ordered in. I do want to point out that no one is required to change theirs. There's when you go to the same one and shop for one, that's what will hopefully be available in commerce after January 2024. Referring again to the underlying bill, in section 7, there are types of prohibited the prohibition does not apply to these are specialty purpose signs. In section 4, we point out that the existing programs that have for more than a decade that allows you to take a light bulb containing mercury through your hardware store or transfer station. Those programs will continue because there are going to be many of these things still in the state for years to come. Second page of the bill, in January, July 1, 2022, the key vote was the economic benefits that go along with it. A typical school will see savings on the order of $24,000 a year. And by 2040, it's estimated this amount to see savings of $167 million by virtue of making this switch at this time. So it's an environmental win, a health win, it's an economic win. It's consistent with other changes that we've made in past bills of this nature. We would ask the Senate to support an actual motion to concur with the House.
Thank you, Senator. I'm going to kindly ask you to repeat the committee vote. I believe it cut out. Senator.
Close it again.
Madam President, please take
this small audience here.
Senator, unfortunately,
I believe it's in the calendar.
0 is the issue.
Thank you, Senator. Does look like we may be having another technical difficulty. The Senate will stand in recess until the fall of the gavel.
too much.
The Senate will please come to order. We're returning from a brief recess due to a technical difficulty. The senator from Addison and the chair of the Committee on Natural Resources and Energy had just reported the committee vote. And I will move to the question, which is, shall the bill be read for the third time? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. Those opposed, nay. The ayes have it, and you've ordered third reading of H 500. We now have on the calendar for action H 96, an act relating to creating the Truth and Reconciliation Commission. It was read for the first time on March 29th. It was referred to the Committee on Government Operations, which reports that it's considered the bill and recommends that the bill be amended as set forth on pages 4190 to 4201 of today's calendar, and that when so amended, the bill ought to pass. The bill was then referred to the Committee on Appropriations, which reports that the recommendation of amendment of the Committee on Government Operations be amended as set forth on page 4201 of today's calendar. Amended, the bill ought to pass. Please listen to the second reading of H 96.
H 96, an act relating to creating the Truth and Reconciliation Commission.
The senator from Chittenden, Senator Ron Hinsdale, is recognized for the report of the Committee on Government Operations.
Thank you, Madam President. If I may, I will speak to the amendment and the underlying bill.
You may.
H 96 creates a Truth and Reconciliation Commission for the state of Vermont, and specifically those in communities harmed by past and recurring institutional and government-sanctioned discrimination and repression. Our colleagues in the other chamber, who also led on JRH2 last session, the apology by the General Assembly for its role in the eugenics survey, see H 96 as a continuation of the work begun with that joint resolution. Namely, the resolution passed unanimously last year concluded with the following. It is resolved that the General Assembly continues to work to eradicate the lasting legacy of its prior actions by listening to and working with the affected individuals and communities. And be it further resolved that the General Assembly recognizes that further legislative action should be taken to address the continuing impact of state-sanctioned eugenics policies and related practices of disenfranchisement, ethnocide, and genocide. H 96 begins to advance the further legislative action we collectively sought and approved last session. We know and appreciate that the House also took testimony on existing models of advancing truth and reconciliation in Canada, Maine, and South Africa, some of the greatest examples of models to reckon with harm based on anti-Blackness and Indigenous erasure. Madam President, may I quote from the intentions of the Canadian Truth and Reconciliation Commission? There is an emerging and compelling desire to put the events of the past behind us so that we can work towards a stronger and healthier future. This is a profound commitment to establishing new relationships embedded in mutual recognition and respect that will forge a brighter future. The truth of common experiences will help set our spirits free and pave the way to reconciliation. Madam President, what is beautiful about this statement is the recognition that we are all more free when we examine the truth, even when it's hard, especially when it's hard. We cannot truly put the past behind us until we have reckoned with it, and that is what H 96 is asking us to do. Before I walk through the various sections of the bill that help us arrive at a formed commission, I want to emphasize that many voices from marginalized communities that have suffered institutional harm were heard in the creation of this process in the House. We might have taken a more hierarchical and therefore efficient approach to selecting the three ultimate commissioners, but inclusiveness and intention was valued over expediency and efficiency. This approach was bolstered by international experts in processes of reconciliation. Section 1 of the bill is its intent, which is to examine and begin the process of dismantling institutional, structural, and systemic discrimination in Vermont, both past and present, that has been caused or permitted by state laws and policies. Section 2 creates a new chapter in Title I called the Truth and Reconciliation Commission. Subsection 901 are the definitions, and subsection 902 is the organization of the Vermont Truth and Reconciliation Commission and its establishment. It establishes the commission as an independent state entity. It articulates that the commission will have 3 members, and the commissioners will establish 1 or more committees to carry out the truth-seeking process with respect to discrimination experienced by individuals who identify as Native American or Indigenous, individuals with a physical, psychiatric, or mental condition or disability, and the families of individuals with a physical, psychiatric, or mental condition or disability, Black individuals and other individuals of color, individuals with French Canadian, French Indian, or other mixed ethnic or racial heritage, and in the commissioner's discretion, other populations and communities that have experienced institutional, structural, and systemic discrimination caused or permitted by state laws and policies. The commissioners have the authority to appoint committee members who are representative of populations and communities that are centered in each committee's work. Commissioners may appoint no more than 30 committee members across all committees. And committee members may receive state funded per diems for up to 8 meetings per year and may use outside funds to provide per diems for additional meetings. Subsection 903 establishes the 3 commissioners in the bill. They are full-time exempt state employees, and their pay is half of a superior court judge, which is a salary of $84,500. Their term ends on July 1st, 2026. Subsection 904 is the selection panel, its membership, and its duties. The selection panel is chosen by September 1st by the Executive Director of Racial Equity, the Executive Director of the Vermont Center for Independent Living, a member appointed by the Speaker not currently serving in the General Assembly, a member appointed by the Committee on Committees not currently serving in the General Assembly, and an individual appointed by the Chief Justice of the Vermont Supreme Court. Overall, the selection panel will have 7 members who will serve until January 15th or March 31st, depending on the time it takes to select commissioners. They may hire temporary administrative staff to assist with the selection process, and they are entitled to per diem compensation for up to 20 meetings. Subsection 905 is the process of selecting the commissioners. So again, the selection panel shall select the commissioners by December 31st of 2022, but they may extend that to March 31st of 2023 if necessary. Finalists will have a private interview with the selection panel, and the public will be able to meet and ask questions of finalists during a public hearing. Commissioners selected by the panel shall be residents of Vermont, not be members of the selection panel, and have knowledge of the problems and challenges facing the relevant named communities. Subsection 906 bestows the powers and duties to the commissioners. Commissioners are required to establish the committees to examine how state laws and policies have discriminated against the relevant communities, determine the scope and objectives of the committee's work, develop a process for committees to achieve those objectives, work with the committees and commission staff to carry out the work with committees and commission staff to identify programs and activities to improve opportunities in the relevant communities, and to educate the public about the discrimination that the commission identifies. They are also required to ensure that the commission's work is open, transparent, inclusive, and meaningful, and finally to supervise the executive director of the Truth and Reconciliation Commission. The commissioners may adopt necessary rules and procedures, secure office space, hold public hearings, and consult with experts, conduct interviews, research, and other activities necessary to examine discrimination caused or permitted by state laws and policies, hire consultants or contractors necessary to help perform the work, take other actions necessary to carry out their work, and raise additional funds to support the commission's work. Subsection 907 creates the position of an executive director of the Truth and Reconciliation Commission. The commissioner shall appoint an executive director, and they shall be a full-time exempt state employee. The executive director's duties include supervising staff and assisting commissioners with carrying out the duties of the commission, facilitating communications between the commission and interested parties, and preparing an annual budget. Subsection 908 are reports due. An interim report is due on January 15th of 2024. The final report of the Truth and Reconciliation Commission is due on June 15th, 2026. And the draft of the final report must be made available for public review and comment by January 15th of 2026. The commission may issue additional reports as they determine appropriate. Subsection 909 is access to information and confidentiality. This is all important when talking about past acts or sanctioned acts of the state that people may want to tell their story around, but may not want it further told publicly. The commission shall have access to records and information held by all state entities. Those state entities are required to cooperate with the commission and provide records to the extent permitted by law. The commission must maintain the confidentiality of information and cannot include any personally identifying information in any report without the express written consent of an individual participating. The commission may make anonymized information available to the public, and the commission must provide interviewees with the opportunity to have the interview conducted in private and adopt procedures to ensure that personally identifying information is not disclosed during any public interviews. Section 3 is the appropriation of the bill. It is estimated that $748,000 will be needed for FY 2023, and that is what is appropriated. And it is estimated that $1.3 million will be needed ongoing for FY 24 to 26. Section 4 of the bill is its repeal. This commission is not designed to be a permanent fixture of state government. It is designed to do work that advances truth and reconciliation and then sunsets. And so the commission sunsets on July 1st of 2026. Section 5 is the effective date, which is upon passage. Madam President, building upon the extensive witness list of the House Committee of Jurisdiction, your Committee on Government Operations heard from the Vermont Development Disabilities Council, the lead sponsors of the original short form bill, the House Committee on Government Operations, the Executive Director of the Office of Racial Equity, the Vermont Racial Justice Alliance, our Office of Legislative Counsel, the Chair of the Vermont Commission on Native American Affairs, the Chief of the Nulhegan Band of the Coosac Abenaki Nation, the House Committee on General Housing and Military Affairs, Mad Freedom, and the Executive Director of the Vermont Human Rights Commission, and the Chief of the Abenaki Nation. Madam President, in closing, I would like to quote the late, great Archbishop Desmond Tutu, who passed away last December and left us with the great gift of helping to craft one of the most compassionate and meaningful truth and reconciliation processes in the world, if I may.
Okay.
Forgiving and being reconciled to our enemies or our loved ones are not about pretending that things are other than they are. It is not about patting one another on the back and turning a blind eye to the wrong. True reconciliation exposes the awfulness, the abuse, the hurt, the truth. It could even sometimes make things worse. It is a risky undertaking, but in the end, it is worthwhile, because in the end, only an honest confrontation with reality can bring real healing. Superficial reconciliation can bring only superficial healing. Your Committee on Government Operations advanced H96 on a vote of 4-1-0, and we ask the body for its support.
Senator from Chittenden, Senator Baruth is recognized for the report of the Committee on Appropriations.
Thank you, Madam President. The audio has been a little bit inconsistent, so I hope you'll be able to hear my report.
I will interrupt you if we cannot.
I'm sorry, what was that?
I said I will let you know if we cannot hear your audio.
All right, thank you very much. The Appropriations Committee, in this case, reviewed the per diems for the selection panel, the $748,000 reconciliation commission. We had a long, detailed walkthrough from the Senator Chittenden, and we appreciated that. There was some sense that the language used in the bill to create the 4 positions was not quite the language that appropriations generally is. And so senators will see on page 4201 of the calendar that we have a very brief technical amendment that lays out the establishment of those 4 positions. So we were supportive of the $730,000 for positions and approved, and with that amendment, we voted 6-0-1 to amend and then forward the amendment. Thank you, Madam President.
Thank you. The first question is, shall the report of the Committee on Government Operations be amended as recommended by the Committee on Appropriations? Are you ready for the question? The senator from Caledonia is recognized.
Thank you, Madam President. May I inquire of the reporter of the Appropriations Amendment?
Okay.
Madam President, I'm somewhat confused. If I understand the amendment correctly, the Appropriations Committee has agreed with one executive director, one staff attorney, one researcher, and one administrative assistant. Did the committee discuss the requirement of up to 30 subcommittee members?
Could I, Madam President, the audio was cutting out. Can I ask the senator to repeat his question?
You may, Senator, I may request, if it may be helpful, just to speak a little bit closer to your microphone.
Microphones are up here.
I believe the microphones are.
In which case,
boxes, not on my table. I don't know if I turn to the screen, whether that makes any difference.
It does.
It does, actually.
That's how we.
Well, Madam President, I'll try again. I noted the amendment calls for approval of an executive director, a staff attorney, one researcher, and one administrative assistant. The bill calls for up to 30 subcommittee members, and I'm curious as to whether Appropriations discussed what it would cost and whether the committee approved the hiring of up to 30 subcommittee members.
We did discuss is, as the senator noted, Madam President, up to 30, so not necessarily 30. But this is all, at this moment, supposed to come from $748,000. As the senator from Chittenden noted, is ongoing cost for next year of well over $1 million. But for this initial phase, $748,000 is other payments for those panel members, if they are a panel.
Thank you, Madam President. I also noted that the bill on page 4198 calls for the hiring of consultants and independent contractors to assist the commission. Were those entities included within that roughly $750,000 discussed by the committee?
I believe that's the case, Madam President, that the overall startup cost is just around $750,000, including those needs. There is always a budget adjustment should it turn out to be undershot, but for now, that's my understanding.
And Madam President, finally on page 4197, I noticed that there was essentially permission to establish and maintain a principal office. Did the committee discuss what the cost of that would actually be? And is that included in the roughly $750,000 approval?
My understanding is that the appropriation that the Senate received at the end of the bill is the cost for what is contained in the country. And again, I would also caveat that should it turn out that this group needs more than that in order to meet their startup budget, they would have the opportunity to come to the appropriations committee in January during budget adjustment.
I thank the Senator. Madam President, just to clarify, we are about to vote on the amendment. Is that correct?
That is correct.
Thank you, Madam President.
The question is, shall the report of the Committee on Government Operations be amended as recommended by the Committee on Appropriations? Are you ready for the question? The senator from Chittenden is recognized.
Madam President, if I may, I think the senator from Caledonia's questions are entirely appropriate, and they're represented more clearly in the fiscal note, which I can get to the senator from Caledonia before third reading. But I also wanted to clarify that the 30 members who are up to 30 members who can be assigned to committees are authorized a stipend of up to $1,000 a year for serving on a committee. They're not considered exempt positions. And so this was clarifying language for the ongoing positions that are created.
Take a little recess. Take a recess.
I would offer the opportunity for a recess to get people the fiscal note if that's helpful.
Clarity.
The Senate will stand in recess until the fall. The gavel. Senate will please come to order. The senator from Chittenden is recognized. We're just returning from a brief recess.
Thank you, Madam President. My apologies to the body, I think, for potentially creating more confusion. Things have been moving quickly. Our joint fiscal office has been quite busy. And in my zeal to separate the committee members who are not going to be exempt staff positions, I was incorrect in articulating that they are being offered stipends of $1,000. They are authorized, as I said in my report, for a per diem for up to 8 meetings annually. But the $1,000 stipend was struck by House Appropriations. So we currently have a fiscal note that was only relevant before it made it to the Senate committee, your Senate Committee on Appropriations. I can let the senator from Caledonia speak for himself, but I don't know that we will get an accurate fiscal note by tomorrow, but all of the dollars appropriated are encompassed in the projected amounts that are reported, which overall is expected to be at or less than $4.5 million over 3.5 years. Thank you, Madam President.
The question is, shall the report of the Committee on Government Operations be amended as recommended by the Committee on Appropriations? Are you ready for the question? All those in favor, please say aye.
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 Those opposed, nay. The ayes have it, and you've amended the report as recommended by the Committee on Appropriations. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Government Operations as amended? Are you ready for the question? The senator from Franklin is recognized, and that'll recognize the senator from Caledonia.
Thank you, Madam President. May I inquire the report of the bill?
You may.
I'm looking at the bill, particularly as it appears in the calendar, and issue of intent. There are a number of statements relative to intent, including examining and beginning the process of dismantling institutional, structural, and systemic racism in Vermont. And I'm particularly concerned with the issue, including prejudice, that has been caused or permitted by state laws and policies. I'm wondering if the committee took any testimony with respect to this and the other two findings, particularly in terms of systemic racism in the present in state laws and policies.
Madam President, if I may clarify from the senator from Franklin, my reading of it is that it says institutional, structural, and systemic discrimination in Vermont, both past and present. I might need a brief recess or a better understanding of where the senator is seeing racism named.
Discrimination is the phrase that is used in there, and that is the phrase that I'm referring to.
Okay. Can the senator repeat the question around discrimination?
Sure. I'm concerned, just asking the question as to whether the committee took any testimony about institutional, structural, and systemic discrimination in the present that has been caused or forbidden by state laws and policies.
Madam President, as I tried to articulate in my report, we certainly relied on the many weeks of testimony that the House was able to engage in around this bill. And we did have witnesses in to mostly focus on how to improve the language, particularly as it related to people with disabilities or conditions that were listed. So that's a change that we made to recognize that in the present, people may have a disability, a perceived disability, or a condition that causes discrimination, and there was significant discussion around that. Other than that, I would have to get more clarity from the senator if there was particular testimony he hoped that we would take.
Thank you, Madam President. Well, I'm looking in particular at section 902 B, which lists a series of groups that are focused on potential allegations of systemic discrimination. And yes, those who have disabilities are included, but also individuals who identify as Native Americans or Indigenous, Black individuals, individuals of color, French Canadian, et cetera.
Was there any testimony regarding any discriminations, particularly systemic discrimination caused by Vermont's laws and policies in the present that related to any of these groups?
Madam President, I would characterize all of the testimony we heard as looking at past original sins of this country, largely centering on the erasure, in some cases forced erasure, of Indigenous peoples and the enslavement of Black Americans as something that we in some form acknowledged has a legacy that continues into present forms of discrimination. But we did not take specific testimony on instances of present day systemic discrimination as a committee.
Madam President, as I read this particular language, the intent is to examine something that exists. And is it my understanding that there was no testimony that, particularly with respect to present discrimination for the majority of those groups, that establishes that such discrimination in fact exists?
Madam President, this is not language that we changed from the original House bill that came over to us. I would be happy to ask our colleagues in the other chamber what kind of testimony they took on the legacy of past discrimination and how it influences present day discrimination that the commission might look at. And I can get that to the member upon third reading, but that was not language that we changed in our proposal of amendment.
As I look at this in terms of the number of people involved, I want to make sure I understand the people. There will be 7 people who will select 5, who will select 3, who will select 30. And somewhere in there, someone will hire 4 more, for a total of 49 people associated with the operation of this commission. It strikes me that did the commission, did the committee examine the number of people involved and why such a large number of people were necessary?
Madam President, that was a point of discussion in our committee. Certainly, that was a discussion that centered around the testimony that was also heard in the House.
I'm sorry, except for just a moment. I am hearing a cell phone or some electronic device coming from our senator zooming in today, and it's highly distracting. So I kindly ask that this body remember the rules of the Senate and not use phones while the Senate is in session. The senator from Chittenden may continue.
Thank you, Madam President. I was feeling distracted, so I appreciate that. So as I said in my report, I think some of the testimony that the other chamber was able to take that we didn't benefit from was the creation and ongoing work of other truth and reconciliation commissions around the globe. And what was conveyed to us clearly is that when you are engaged in such an undertaking, the process is just as important as the outcome. Excavating the truth and creating a healing process for reconciliation is likely to involve many actors who are able to capture a broad range of perspectives and ultimately place a huge amount of responsibility on commissioners and one executive director. And so what we heard conveyed was that it's very important that we have a larger community that is engaged in and bought into this process that ultimately will rest on 3 commissioners and 1 executive director who are compensated at a far different rate than the rest of the people involved.
Thank you, Madam President. One of the findings, one of the intent statements refers to identifying potential actions that can be taken. Was there any testimony provided to the commission as to examples of the potential actions that people interviewed by the committee were going to likely suggest?
Madam President, I don't want to misspeak because examples of actions that could be taken came up after the passage of JRH2, the eugenics apology, as well as then the creation of this commission so that they could look at those actions and make sure that a maximal number of people felt those actions were appropriate. Those could be things like an art installation or a plaque or a gathering or event. I hope it doesn't seem tangential to reference some of the work we did in this body around the statute of limitations related to childhood physical and sexual abuse. That was actually an action taken out of a restorative process with the former orphans of the St. Joseph's Orphanage, where there was public dollars that went into a reconciliation process for them. There is a exhibition at our historical society just next door that articulates what those dollars went to and how that essentially that truth and reconciliation process unfolded. So, I don't want to limit the scope of what actions could be taken, but we ourselves have been part of a restorative process of passing laws that repair past harm.
Was there any specific reference given to the committee regarding the concept of reparations?
Madam President, those words were certainly uttered, and there were those in organizations that did not feel that the Truth and Reconciliation Commission did enough to, in fact, repair economic harm or look back at the need for reparations specifically for the descendants of slaves. So that conversation did come up. There may actually, I don't want to misspeak, but there may be an entirely other effort that we take into consideration either in this biennium or future legislative bienniums around that topic. But those who felt most strongly in the advocacy community about a reparations-based discussion did not ultimately see this as a vehicle for that conversation.
Thank you, Madam President. As I look at the bill as it states right now, the notion of determining what happened in the past, you have to admit, lots of bad things happened in the past. And there certainly is bias and discrimination that exists in the present. But whether or not it's systemic, and certainly whether or not there are policies and practices today in the state of Vermont that are abhorrent, such as the policies that existed during the time of slavery, or for that matter, during the time of the eugenics movement. The question is there any evidence of that? At least evidence of that would warrant the creation of a 49-member colossus at $750,000 plus $1.5 million over the next 2 years to deal with. I think this is excessive. I think we could take $2.25 billion and help deal with the child care crisis. I think we could take $2.25 million and send poor kids to school. I think there's so many things that we could do with that huge amount of money, but to spend it on 49 people engaging in a search for past discrimination, I don't think is a good use of money. Many of these kinds of things are things that are done by historians, and I understand the Desmond Tutu example. But Vermont is not apartheid South Africa. Within 5 to 10 years after apartheid ended. I don't think this is a good use of money or a wise use of time or a good expenditure for this body to make. And I will be voting against this bill. Thank you.
I believe the senator from, question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Government Operations as amended? And the senator from Windham is recognized.
Thank you, Madam President. I'm not going to decide whether it's a good use of money or not and weigh it against other things, but I do want to respond to a couple of questions that were asked, and I think the senator from Chittenden spoke well to them, but just to reinforce, we did hear that COVID had an outsized impact on Native Americans and people of color. That may not have been systemic discrimination, but it was caused by non-policies by the state rather than active policies. Many people define in multiple communities. You might have somebody who defines as a Black Vermonter and also a person with psychiatric problems or someone in a wheelchair. So people define in different communities. And very recently, and I can get the exact date, there was a decision by the state to not allow someone who was considered feeble-minded to marry and have children. So that is a very recent policy, and that is systemic discrimination. I will say another one that may not have been systemic discrimination, but certainly was caused by not addressing issues that needed to be addressed, was the Somalian refugee who wanted to become a state trooper, who, when he was perfectly capable and passed the physical and everything else. When he took the written exam, the way the written exam works for law enforcement is that they give a scenario, and then they give 4 or 5 written solutions. Which would you do? So because English was not his first language, and we know very well that English is a very complicated and kind of nuanced language, he failed that. After working with the academy, those questions were changed, and he did become a strict trooper. So that wasn't necessarily a system that was put in place to promote discrimination, but it did. And so I think there are many examples of current discrimination that are supported by state laws or state policies, and we need to address those. Thank you.
Senator from Caledonia is recognized.
Thank you, Madam President. May I inquire of the presenter?
May.
Madam President, I'm looking at the bottom of page 4197 in today's calendar and see subsection 8 that would allow these entities to enter into cooperative agreements with private organizations or individuals or agencies. I'm curious, Madam President, what testimony did the committee take and what was identified as something that this entity would need to enter into such contractual obligations?
Madam President, some of this language is very specific about instrumentalities of the United States, and I don't think we got into identifying what a specific cooperative agreement or why we would need to have a cooperative agreement with an instrumentality of the United States would necessarily be. I can guess at the Bureau of Indian Affairs or a number of other organizations, past and present. But I would be happy to get the senator, more information before third reading, because I imagine that was very specific and intentional on the part of the other chamber.
Madam President, I'm looking at the next section, which asks the same with respect to legal documents. I am curious as to what testimony was taken. What was identified that would require this entity to have that power?
Madam President, I would request a brief recess just to make sure I understand what might be language when you're creating a commission of this magnitude and what might have been specific to the creation of the commission, if I may.
Senate will stand in recess until the fall of the gavel. Senate will please come to order. We're returning from a brief recess requested by the senator from Chittenden. The senator from Chittenden is recognized.
Thank you, Madam President. During our brief recess, I was able to confirm with our legislative counsel that much of this was intended to be standard language that bestows powers upon a commission that we might stand up as a chamber or as a legislature. But in addition, that this language is underscored by testimony that was heard in the other chamber.
Point of order, Madam.
Senator from Bennington is recognized.
Madam President, I keep hearing about testimony in the other body. I didn't think we were supposed to take that in consideration in our committees nor on the Senate floor.
The senator from Bennington's point of order is well taken. It's my understanding that in reporting a bill, this body's testimony is what should be referred to and spoken on.
Thank you, Madam President. What I will try to do is articulate it as testimony we heard in our committee from the other chamber, if that's acceptable. In the testimony that was taken in our committee around the development of this language, we agreed with the further underscoring of language that would allow this commission to operate independently, recognizing that it's examining past practices of state government or sanctioned actions by state government. This language is intended to further underscore the powers and independent duties of the commission, but is not necessarily language that's unique to this particular commission. What we have heard from our legislative counsel is this could be entering into a cooperative agreement with any entity such as our Vermont Law School here in the state, or it could be a national organization that focuses on Truth and Reconciliation Commission, but that many commissions have the authority and power to enter into cooperative agreements, particularly if they require independence to do their work.
Senator from Caledonia.
I thank the senator for obtaining the answer to the question. Madam President, I'm very troubled by this bill, frankly. I do understand I run the risk of identifying myself as someone bigoted about statements that I might be about to make. I was initially reading this bill with an understanding that this was an attempt to further a process. After reading the bill, I see this as bureaucratic overkill to a process that has begun long ago. I will start, Madam President, with the very first intent statement. This brand new entity would begin the process of dismantling institutional and structure and systemic discrimination in Vermont. Madam President, some of you may know I love to ride a motorcycle, and I've traversed the North American continent, visiting places like Wounded Knee, where I stood in and looked at a mass grave. I've followed the path of Chief Joseph and the Nez Perce, who were trying to escape the United States Army. I have visited Brunswick Springs here in Vermont and happily voted for the Abenaki to be able to be relieved from property taxes for places like that. But perhaps most importantly, Madam President, I did at one time serve as the chair of the Human Rights Commission. When I read a statement that pretends to say that this new entity would be the way we begin the process of dismantling discrimination, I find that very problematic. Because in my days as chair of that commission, then Police Chief Michael Sherling was before our commission, and we had identified a racial disparity in police stops. And it was our commission that got him interested in suddenly creating the statistics that were necessary to examine whether there was a problem. That process has been continuing for over a decade now, as the police agencies themselves are in new training that has been fostered along the way over the past 10 years, even to the point where I was part of government operations was some time ago. The concept of discrimination is certainly something we should be addressing, but not with bureaucratic overkill. We have established an Office of Racial Equity. We have just recently provided another organization with the ability to collect statistics and make a report on what kinds of things they are observing. We have just today passed additional language talking about statistics that should be gathered. That's a process that's been going on for over a decade, but now to suddenly be faced with 49 individuals on a brand new commission is very troubling. And if one reads deeply into the language of the bill itself, this is a commission that could very well get out of control in a hurry based on politics. And that is not something we should have injected into the middle of the conversation. There is every reason under this bill, if this commission is established, for people to come and vent their frustrations. We already understand the frustrations. We may be still identifying pieces that need to be addressed, like restrictive covenants. But when those pieces are identified, we need to come together as a unified state and talk to each other, break bread with each other, and figure out a way to get around that process. We already have the ability to acknowledge what has gone wrong. We may still be discovering some things that need to be tweaked, but to do so with an oversized, literally uncontrollable, if you read this language, that is going to be causing all kinds of people to react and eventually lay the groundwork to put us all into a very difficult political position of whether certain citizens should be paid sums of money from the pockets of other citizens who never had any intention of acting with discrimination. And I think that we owe it to ourselves and to our posterity to understand that's not the way we should be setting up government. So I understand and appreciate the efforts of the committee, but Madam President, I find myself unable to vote for this bill, and to certainly leave by saying I don't think it's ready for prime time, Madam President.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Government Operations as amended? The senator from Orange is recognized.
May I interrogate the reporter, the bill?
You may.
I've read through the bill. I didn't see anything, Madam President, about reparations. Is there anything in the bill about reparation?
There is not, Madam President.
So I'm surprised. Thank you. I was surprised that learned counsel would stand up and suggest that we had to deal with reparations and that perhaps he was troubled about that, but it's not in the bill. Madam President, reconciliations have taken place in a variety of venues, and they've always been opposed by people of goodwill who don't want to stir things up. They don't want to hear about our past. It's embarrassing sometimes when we confess what we've done. I know some religions know that confession is good for the soul and have opportunities to do that, but they're not public. I'm quite shocked here today at what seemed to be a benign opportunity for people who believe they have a history of second-class citizenship, of being always at the end of the line because of who they were, not because of how they behaved. And being told here on the floor of the Senate that if we learned from our neighbors about such things, that this would stir up political problems. And, I mean, defeat cost money, reparations, which isn't in the bill. I've read some reparations that, excuse me, I've read some of the results of the reconciliation in South Africa and been astounded at both the testimony that people spoke before the commission, but also by South Africans who had participated in activities that they weren't proud of and looking back thought were wrong. I would expect that if the fears of those who say here today, those senators who suggest we don't need this, that the best thing that could happen is we would have this committee, this forum, and no one would show up. No one would show up because nothing was reportable. Nothing was necessary. We live in this state because we love it. We live in this state because we like its people. We live in this state because there's no other place we would like to be. And I don't know why we fear, why we are reluctant to hear that perhaps our state has some imperfections. And we have some senators seem to be reluctant to listen to what some of our neighbors might say. We listen to them about everything else. But if there's something in our past that we're afraid to hear about, then the best way to not have to hear about it is kill this bill. Thank you, Madam President.
Senator from Washington is recognized.
Thank you, Madam President. I'm going to voice a concern. We have a bill before us to set up a specific commission with a specific budget and a specific layout. All right. But the discussion has very quickly turned to, if I don't think this is the appropriate structure, if I don't think this, I've heard about South Africa and Canada. Those are nations. We are Vermont. And is this the appropriate structure is one question. But when it gets cast into well, if you don't vote for this specific structure, then you don't want to hear about all the bad things we've done. I have never been afraid to hear or to speak. And I am probably the only one in this body who has actually lived with a family of color in a ghetto and been the only white face at African American night at the local church. I will stand on my record on justice, but I don't like having it cast that this vote is a vote for or against reparation or for or against acknowledging. It is a vote for or against whether this is the best way to structure and to structure our response to misdeeds of the past. And I hope we can make that distinction clear. Thank you.
Question is, shall the Senate propose the House to amend the bill as recommended by the Committee on Government Operations as amended? Are you ready for the question? The senator from Chittenden is recognized.
Madam President, the truth is messy, and the truth belongs to all of us. And so often we have unspeakable truths that are so hard to talk about. And when we have those unspeakable truths as government, what do we do? The senator from Franklin actually brought up an incredibly poignant example of what we could be doing with these dollars. The senator spoke of sending children to school and making sure children are fed. And at the heart of this bill is the acknowledgement that there are branches of families in Vermont that have lost that sacred right to send their grandchildren off to school, to make sure that they can nourish generations of their family to come. Our state sanctioned and supported the sterilization of human beings in Vermont. That was nearly 100 years ago. And then nearly 50 years ago, it required a lawsuit for us to share basic information about who was impacted and have basic rights to access family information of people who experienced that ultimate loss of their liberty and freedom. And it took us until last year to apologize for that as state government. Some of us remember a decade ago, probably longer, when we started to try and articulate that deep regret and deep apology to so many, to hundreds of families in Vermont for what we had sanctioned and what we had done. And that apology was buried in bureaucracy for so long because we were so afraid that we couldn't quantify the impact of what we had done to families. Not only families in Vermont, but how do we even begin to quantify that a professor of zoology at our own esteemed public university led the American Eugenics Survey? There are not enough millions of dollars in state government to repay the harm that we caused for so many years, and for a century after that, for not even being able to say, I am sorry. We did that last year, and we promised that just articulating the truth of what had happened would not be where we ended. That we would then begin our best attempt at putting the power in the hands of the people most impacted to figure out what healing and reconciliation would look like. It is not our responsibility to figure out what that looks like. It is in the hands of those who have been most impacted by decisions that our bodies had sanctioned, that our government had allowed to happen. Whether or not we agree with what had happened in the past, we now own institutions that caused that harm. And it is up to us to decide how we take that truth, how we take that pain, how we take that ugliness, and begin to heal from it. This bill has a few $1 million that can never make up for the damage that we caused so many families. So I ask that you make this small investment in illuminating and repairing the harm that our institution that we hold so dear has done to our fellow Vermonters. Thank you.
The senator from Essex Orleans is recognized.
Madam President, history always seems to be discovered. We always seem to find out. History sometimes isn't something that's very pretty. But it just seems to me that we raise a lot of issues here that we're concerned about, and that we already have government, we already have programs, we already have institutions that can discover the answers to our questions. I don't know if we need to spend $2.5 million, but if you start doing the math, it's up to $5 million. And it could easily be, as the senator from Caledonia has said, it could easily be something that's out of hand. There's a lot of what I would see unfunded mandates in there that you could hire this person or hire that person. And yes, we could go to a budget adjustment. But it just seems like if we have these concerns, we probably already have the structures in place to go find the truths, to go find the answers of what we're looking for without spending all this money and empowering 49 people plus to look for something that we want to go find the answers to. We already have the people to do that. Thank you, Madam President.
I believe the senator from Franklin is recognized.
Thank you, Madam President. This is not to say that there isn't discrimination in Vermont, but there isn't discrimination based on law. We've made a lot of progress in the past 30 years, 50 years, 100 years, 200 years. It's not the same as it was then. We don't enslave people. We don't prevent people from getting jobs, at least officially. We don't prevent people from doing all kinds of things in which they become or victimized by systemic discrimination. I look back at my life, and I've told stories, I think, here on the floor from time to time of some of the experiences I've had over the years, in which I think I may have told you of one of those memories that I have about the two drinking fountains. One chipped and yellowed, the other bright, shiny aluminum, and being told that I couldn't drink out of one of them because of my race. That was then. This is now. And now we're looking at discrimination that is systemic in nature and that is state-sponsored, and that we have to root it out. I agree with that. If there is such a thing, we do need to root it out. But that's why we have a Human Rights Commission, which I support. That's why we have an Executive Director of Racial Equity, who I support. That's why we have an Attorney General's office, who goes after issues of discrimination that I support. But we don't need a 49-member, $2.25 million commission to go on for 3 years, tell us what happened in history and how to deal with it. We have people that we've been paying for years to do it, and they're making progress in doing it. Do they do it perfectly? No. Do any of us do anything perfectly? This is unnecessary. This is overkill. This is the epitome of bureaucratic overreach, and it's intrusive. And I think it should not be passed. Thank you, Madam President.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Government Operations as amended? Are you ready for the question? Senator from Orange is recognized.
Madam President, there's no happy way to learn about things that make us unhappy.
Are you ready for the question? Question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Government Operations as amended?
Roll call.
The senator from Franklin has requested a roll call vote. Are you ready for the question? Secretary is kindly asked to call the roll.
Senator Ballant.
Yes.
Senator Baruch.
Yes.
Senator Bennon.
No.
Senator Bray,
Yes.
Senator Brock,
No.
Senator Campion,
Yes.
Senator Chittenden,
Yes.
Senator Clarkson,
Yes.
Senator Collmore,
No.
Senator Cummings,
Yes.
Senator Hardy,
Yes.
Senator Hooker,
Yes.
Senator Ingalls,
No.
Senator Kitchell, Senator Lyons,
Yes.
Senator McDonald,
Yes.
Senator Mazza,
No.
Senator McCormack,
Yes.
Senator Nitka,
Yes.
Senator Parent,
No.
Senator Pearson,
Yes.
Senator Perschlick,
Yes.
Senator Polina,
Yes.
Senator Ram Hinsdale,
Yes.
Senator Sears,
Yes.
Senator Saratkin,
Yes.
Senator Starr,
No.
Senator Terenzini, Senator Westman,
Yes.
Senator White,
Yes.
Senator Terenzini,
Please listen to the results of your vote. The yeas 22, the nays 7, and you propose the House to amend the bill as recommended by the Committee on Government Operations as amended. The question now is, shall the bill be read for the third time? Are you ready for the question? All those in favor, please say aye.
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 Those opposed, nay.
No.
The ayes appear to have it. The ayes do have it, and you've ordered third reading of H 96. The senator from Wyndham is recognized.
Thank you, Madam President. Pending announcements, I move that the Senate stand in adjournment until 10 a.m. Wednesday, May 4th.
The senator from Wyndham has moved that subject to any announcements, and to adjourn until Wednesday, May 4th at 10 a.m. Are there any announcements? The senator from Chittenden is recognized.
Thank you, Madam President. I would move at this time that S-101 be called up for immediate action. And by way of explanation, would the next motion being a motion to move this bill to conference committee.
I do believe we need a rule suspension, but I'm happy to add that into your motion.
Thank you.
The senator from Chittenden has moved that the rules be suspended and the Committee on Economic Development, Housing and General Affairs be relieved of S-101, an act relating to promoting housing choice and opportunity in smart growth areas, and the bill be taken up for immediate consideration. Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've suspended the rules and will now take up S-101 for immediate consideration.
It's going to take a second. Yes. And I got to hand out the House proposal amendment because there is a House proposal for the amendment.
The senator from Chittenden is recognized. There is a House proposal of amendment that's being circulated now. We will now take up S-101, an act relating to promoting housing choice in smart growth areas.
The Senate may remember in January, we got this bill back from the House. It was highly unrecognizable. And we asked that the bill be sent back to committee. A lot of good things in the Senate version of this bill, and many of the provisions in this bill are now other vehicles making their way through the chamber. There is one provision that our committee found very important, dealing with a limited duplication of wastewater water permits being required from both the state and municipalities. And we would like that to be considered by a conference committee. The vote was
unanimous in our committee to go to conference and not concur with the House version of S-101.
The question is, shall the Senate refuse to concur with the House proposal of amendment and a committee of conference be appointed? Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay.
Aye.
The ayes have it, appear to have it, do have it, and you've refused to concur with the House proposal of amendment and a committee of conference appointed. Are there any additional announcements? The senator for Windham is recognized.
Thank you, Madam President. At this time, I ask that the rules be suspended and that we message our actions on S280, H456, H464, H482, H523, and H729 to the House forthwith.
The senator from Windham has moved that the rules be suspended and the following bills be messaged to the House forthwith. S280, an act relating to miscellaneous changes to laws related to vehicles. H456, an act relating to establishing strategic goals and reporting requirements for the Vermont State Colleges. H464, an act relating to miscellaneous changes to the REACH Up program. H482, an act relating to the Petroleum Cleanup Fund. H523, an act relating to reducing hydrofluorocarbon emissions. And H729, an act relating to miscellaneous judiciary procedures. Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've suspended the rules and messaged S280, H456, H464, H482, H523, and H729 to the House forthwith. Are there any additional announcements? The senator from Addison is recognized.
Thank you, Madam President. I move that the Senate suspend its rules and that H446, an act relating to miscellaneous natural resources and development subjects, be referred to the Senate Finance Committee for Rule 31 with report of Senate Natural Resources and Energy Act.
The senator from Addison has moved that pending entry on the calendar for notice, the senator from Addison has moved that the rules be suspended and H446, pending entry on the calendar for notice, be referred to the Committee on Finance pursuant to Rule 31 with the report of the Senate Natural Resources and Energy Committee intact. Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've suspended the rules and will now refer H446 to the Committee on Finance with the report of the Senate Committee on Energy and Natural Resources intact. Are there any additional announcements? The senator from Windham is recognized.
Thank you, Madam President. Senate Government Operations will meet in half an hour. That would be at about 1:45. And while I'm up, may I inquire of the pro tem?
You may.
I wonder if it would be possible, Madam President, to have a Rules Committee meeting we have at least 5 charters that are being considered in the House today. And I know the senator from Grand Isle loves so much to have Rules Committee meetings for charters, but I wonder if it would be possible to do that.
Yes, Madam President, immediately following the floor, I could ask the Senate Rules Committee to meet. We can dispatch with those.
Thank you.
The senator from Chittenden is recognized.
Thank you, Madam President. Senate Health and Welfare will meet very briefly tomorrow morning at 8:45.
Senator from Washington is recognized.
Thank you, Madam President. Senate Finance will meet at 10 minutes of 2. I asked the committee, I'm not even sure that we can still get lunch because of cookout, but to eat before we come to committee just for general health reasons.
Are there any additional announcements? The senator from Bennington is recognized.
Madam President, Senate Education will also meet at 10 minutes to 2.
Are there any additional announcements? Senator from Windham is recognized.
Thank you, Madam President. I wanted to let senators know If you hadn't heard, the governor did veto the bill on pensions. And after conferring with the minority leader and the whip on the minority side, we're going to be taking up that veto right tomorrow.
The senator from Windsor is recognized.
Thank you, Madam President. I believe Senate Economic Development will be meeting tomorrow morning at 8:30. That's my first announcement. And my second is yesterday, we had a very important birthday. Tomorrow we'll have another one, but yesterday and today as a result, we are going to celebrate queens and charters. So as many of you know, I serve on Senate Government Operations where we have a queen of many things. And today we celebrate in her honor one of the first charters I'm aware of, which is King Richard I in 1194. King Richard I gave Portsmouth its first royal charter. And in 1670, King Charles II granted a permanent charter to the Hudson Bay Company to open up the fur trade in North America. And as of queens, we not only celebrate the queen to my right, but we celebrate the Queen Catherine the Great, born in 1729. And in 1402, Eleanor of Aragon, the Queen of Portugal. And to clean it all up, we celebrate in light of the bill we were just discussing. In 1994, Nelson Mandela claimed victory in South America's first democratic election, which was astonishing. And in light of our work this year and the work on our Barry Charter, today we celebrate with Poland Flag Day. Oh, and we celebrate the birthday of our own dear Queen of Senate Government Operations, Senator White.
Caledonia is recognized.
Thank you, Madam President. Just to get back to basics, Senate Appropriations will meet later today. We have a committee of conference starting at 1:30. My goal is maybe to reconvene at 2:30, 2:45. We'll text you. We have a couple of bills that we want to get voted out today. Thank you.
Are there any additional announcements? Hearing none, seeing none, the senator from Windham has moved that the Senate adjourn until Wednesday, May 4th at 10 a.m. Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay. The ayes have it, and the Senate stands adjourned until Wednesday, May 4th at 10 a.m.